Hello and a warm welcome to Well This Week by latestlaws.com. This is a weekly program, so hit the bell icon to get notification for new videos. My name is Sheetal June, Associate Editor, latestlaws.com, and let's begin with Supreme Court this week. This week, in a breakthrough decision, the Supreme Court has ruled against the telecast ban on MediaOne, the Malayalam news channel, observing that state cannot halt citizens' right with a national security plea. The division bench of CJI D.Y. Chandrachud and Justice Hima Kohli found no valid reason in the High Court order and directed the ministry to issue the renewal license to the channel within 4 weeks. The court was adjudicating upon an SLP filed by the MediaOne owner against the Kerala High Court judgment of upholding the centre's decision to not renew the broadcast license of the channel for want of security clearances from the Ministry of Home Affairs. The court opined that the government had not provided sufficient reasons to prove substantial concerns over national security, noting that national security claims cannot be made out of thin air. The court emphasized that the presence of material facts backing the same is also necessary. Sealed cover procedure cannot be a normal course of process if less restrictive means can be duly applied to a particular case, it asserted. The top court has made it clear that the courts have the responsibility to maintain a balance between the two aspects, which are the protection of an individual's right to a fair and just trial and addressing the concerns of the state regarding national security. The Supreme Court has observed that trials involving special laws and stringent bail provisions must be concluded speedily. It thus directed courts to be sensitive to the fact that incarnation has deleterious effects on under trials, and if the trial is not concluded in time, the injustice inflicted on the individual is immeasurable. Dealing with the bail plea of an accused under the Narcotics, Drugs, Psychotropic Substance Act, who was behind the bars for past 7 years while the trial proceeded at snail's pace, the court remarked that laws which imposes stringent conditions for grant of bail may be necessary in public interest, yet if trials are not concluded in time, the injustice wreaked on individual is immeasurable. The Supreme Court has opined that the modification in resolution plan after approval are not open for judicial review unless they are violative of the Insolvency and Bankruptcy Code. Further, once the resolution plan is approved, it cannot be modified or altered. In the case, it was observed that the NCLT had upheld the exclusive right to use the trademark of the corporate debtor and further declared that trademarks belong to the corporate debtor. However, the resolution plan only talked about the perpetual exclusive right to use the trademark by the corporate debtor. The court additionally declaration by the NCLT that the trademarks belong to the corporate debtor could not be reconciled with the resolution plan approved by the COC. The Supreme Court has ruled that no service tax would be levied on corporate guarantees provided by a parent company to its subsidiaries, as there is no consideration involved resolving a long-standing service tax conflict. The decision was made in the case of the Commissioner of CGST and Central Excise versus Adlevis Financial Services and is expected to resolve past cases related to service tax on corporate guarantees provided by a parent company to its subsidiaries. However, under the GST regime, even if consideration is involved in a related party transactions, a deemed consideration applies. The companies are required to pay taxes, experts said. In a notable ruling, the Supreme Court has ruled that the 2015 amendment to the sections 153C of the Income Tax Act 1961 shall have a retrospective effect. It means that the amendment brought by the Finance Act 2015 will retrospectively apply to the searches conducted prior to the date of the amendment, that is 1/6/2015. The amendment was essentially brought to substitute the words belong or belongs to pertain and pertains to in order to nullify the 2014 High Court decisions in PepsiCo India versus Assistant Commissioner of Income Tax, where it gave a restrictive meaning to the words belong or belongs in section 153C by holding that the words used in the sections cannot be confused as relates to or refers to. Placing heavy reliance on the objects of the amendment, a bench of Justice M.R. Shah and Justice C.T. Ravikumar ruled that the very purpose of the amendment was to give the power back to the Income Tax Department, which was attenuated by the narrow and restrictive meaning given by the Delhi High Court. Observing that it is necessary to give effect to the manifest intention of the legislature while interpreting the provision, the court stated that once the primary intention is ascertained and the object and the purpose of the legislature is known, it becomes a duty of the court to give a purposive and functional interpretation. It further noted that amendment by substitution has the effect of wiping the early provision of the statute as if the unamended provision never existed, and therefore the retrospective effect of the 2015 amendment is rational. The Supreme Court, led by Justice Bela M. Trivedi and Justice B.R. Gawai, expressed concern over the unnecessary lengthy cases filed by advocates on record. They stated that advocates tend to file needlessly long and complex cases and could be easily and precisely dealt with. saving time for the court and the parties involved. The bench also criticized the lack of accountability for filing a meritless case and emphasized that advocates must be responsible for what they file. The bench further highlighted the importance of caution while making derogatory remarks against the courts or any judge, especially while alleging bias or vindictiveness. Such allegations can damage the reputation of the court and lead to serious consequences. The bench called for more responsible and respectful conduct by the advocates to maintain the integrity and impartiality of the judicial system. Next we have Delhi High Court. Observing that attachment of bank accounts is a draconian step, the Delhi High Court has ruled that such action can only be taken in case conditions specified in Section 83 of the Central Goods and Services Tax Act 2017 are fully satisfied. The division bench of Justice Vibhu Bhakru and Justice Amit Mahajan asserted that it is not open for the tax department to attach the bank accounts of other persons on a mere assumption that the funds therein are owned by any taxable person, and that the exercise of power under Section 83 of the Act must be necessarily be confined within the limits of Section 122 1A of the Central Goods and Services Tax Act 2017. Noting that powers under Section 83 of the Act to provisionally attach assets or bank accounts is limited to attaching the bank accounts and assets taxable persons and persons specified under Section 122 1A of the Act, the court opined that the impugned order cannot be sustained. Cautioning against frivolous PILs which promote personal, business or political agenda, the Delhi High Court has said that courts must carefully weigh if person before it has any personal motive or oblique consideration. A bench headed by Chief Justice Satish Chandra Sharma said that motivated public interest litigations not only pose a grave danger to the credibility of judicial process and consume precious judicial time, but also has the propensity of endangering the credibility of other institutions and undermining public faith in democracy and the rule of law. The attractive brand name of PILs should not be used for suspicious products of mischief and should be aimed at genuine public wrong, it said. Now let's have an overview of other high courts. A single judge bench of the Madras High Court has interpreted the ambit of Section 82 and 83 of the Registration Act 1908, wherein the registering authority is empowered to initiate action whenever a false statement is made before it by any party. The court held that while it is settled that questions of the title should be determined by a civil court and not by a registering authority, the registering authority is however empowered to conduct an inquiry concerning the matters specified in Section 82 of the Registration Act. The Gujarat High Court, while dealing with the issue of willful defaulter, ruled that the intention of the moratorium granted under Section 96 of the Insolvency and Bankruptcy Code 2016 cannot be extended to the proceedings with respect to a borrower who has been declared as a willful defaulter. The interim moratorium under Section 96 of the IBC can be referred only to the debts as mentioned therein. Further, the proceeding of willful defaulter cannot be equated with the recovery or debt. Further, the court opined that an order cannot be set aside solely on the ground that the order of willful defaulter identification committee is a cut and paste order. The Madhya Pradesh High Court has dismissed an appeal filed by a wife seeking setting aside of a decree of her divorce which was sought by the husband on the ground of cruelty. The court held that the cruelty must be understood is in subjective circumstances and it is always dependent upon social stratas and the milieu which the parties belong, their ways of life, relationship, temperament and emotions that are conditioned by their social status. The court relied on the case of V. Bhagat versus D. Bhagat, wherein the Supreme Court held that mental cruelty in Section 13(1)(ia) of the Hindu Marriage Act can broadly be defined as the conduct which inflicts upon the other party such mental pain and suffering as would make it possible for the party to live with each other. In other words, mental cruelty must be such a nature that the parties cannot reasonably be expected to live together. The court further opined that the cruelty is subjective and it must be judged as per the circumstances. If it is a case of accusation and allegations, the regard must also be held to be in context which they are made. Remarking that criminal trial is not an IPL T20 match where every substitute player can be an impact player, the Orissa High Court wasn't impressed with the new State Defence Counsel asked to cross-examine the witness without providing him the police papers and just asking him to inspect the case record. The single-judge bench of Justice S.K. Sahu was of the view that despite all the laxities, his consent was obtained to cross-examine the witness on the day itself and it is a gross illegality causing serious prejudice to the accused. Stressing that the due process of law incorporated in our constitution system demands that a person not only be given an opportunity of being heard before before being condemned, but also such opportunity be fair, just and reasonable, the court observed that it was the duty of the trial judge to provide him legal assistance at the state's expenses by appointing a state defense counsel who would faithfully, diligently, and the best of his abilities discharge his duties in defense of the accused. The Allahabad High Court, while granting anticipatory bail to a man booked under UP Cow Slaughter Act, has observed that the state failed to conduct a fair probe as not enough evidence was to make a prima facie case was available. The single judge bench of Justice Muhammad Faiz Alam Khan noted that the case is a glaring example of misuse of penal law, as neither the prohibited animal nor its flesh has been recovered from the possession of any accused person or from the spot, or any a rope, and some amount of the cow dung has been collected by the investigating officer. Reminding the state of its duty, it asked the IOs to be instructed to ensure fair investigation in all criminal cases in general and in the cases pertaining to cow slaughter in particular. Observing that after death of a husband, remarriage cannot be considered a taboo to get a compensation, the Bombay High Court dismissed the appeal filed by the insurance company and noted that one cannot expect that for getting compensation of deceased husband, the widow has to remain a widow for the lifetime or till getting the compensation. The court was of the view that at the time of the death of her husband, she was 19 years old, and thereafter she filed a claim petition for getting compensation, and during the pendency of the claim, she remarried, and one cannot expect that for getting compensation of deceased husband, the widow has to remain widow for lifelong or till getting the compensation. The Andhra Pradesh High Court has held that refusal to get child medically treated and neglecting his health does not amount to cruelty under section 49A or criminal intimidation under section 506 IPC. The single judge bench of Justice R. Raghurendra Rao, in this view, quashed a criminal case filed by a woman against her husband and in-laws alleging inter alia that no assistance was given for the treatment of her ailing son by the husband. Moving on to miscellaneous news. Congress leader Rahul Gandhi termed his conviction as erroneous, patently perverse, and said that he was sentenced in a manner so as to attract disqualification as an MP. In his application seeking suspension of conviction, Gandhi submitted he was treated harshly by the trial court, which was overwhelmingly influenced by his status as an MP, and maintained that there is no such thing as a definite Modi Samaj or community on record. By the very nature of his task, a politician in opposition cannot always weigh his words in golden scale, he said, adding, hence it is incumbent upon courts to focus on the essence and spirit of the speech rather than on the tone and tenor. He said a strong and uncompromising opposition is the essential requirement of a true and a healthy democracy. While performing his duties as a critique of the government, a member of the legislature is very likely to cause annoyance or embarrassment to those in power, Gandhi stated. The prominent Muslim body Jamaat Ulama-e-Hind filed a petition urging the court to dismiss the petitions regarding the legalization of same-sex marriage. The body contended that the marriages as defined in Muslim law is a union between a biological man and a biological woman, and the definition cannot be replaced or changed. They further argued that the roles of husband and wife are complementary and not interchangeable. The Muslim body also asserted that the LGBTQIA+ movement, although widely accepted globally, should not influence Islamic personal laws. They argued that the idea and philosophy behind such marriage are Western and alien to the socio-religious order in India. The Supreme Court has encouraged advocates to appear via online mode as a precautionary means amid rise in COVID-19 cases in the capital. The division bench of CJI Diva Chandrachud and Justice J.B. Pardiwala during the mention of a matter discussed the news reports and provided the lawyers with the option to appear for virtual hearing. The Indian Constitution's survival hinges on the nation's demographic profile, and if it is altered, then it would cease to exist, Judge of the Madras High Court, Justice G.R. Swaminathan has said. Addressing an event, Justice Swaminathan made a quick reference to the making of the Constitution between 1947 to 49 and its coming into force in 1950. The Ministry of Electronics and Information Technology has notified the final rules for online gaming. The new rules come after the draft regulation that were issued in January 2023. The new rules for online gaming prohibit any game that involves betting and wagering. Permissibility will be determined with the simple principle of whether wagering is involved. Apart from SRO, the IT Ministry has also notified a mandatory KYC verification for online gamers of games involving real money. Under the new rules, MIT will also notify agencies to fact-check false and misleading information related to government business. The Kerala High Court has issued first of its kind data privacy notice in a significant development in the protection of individuals' privacy rights. The notice provides specific guidelines for collecting and withholding personal data and has been directed to be published by the High Court and district courts in both English and vernacular languages for benefit of the public. This move by the Kerala High Court highlights the increasing importance of privacy rights in today's digital age. The guidelines set forth in the notice provide a framework for judges to balance the right to privacy with the public's right to access information. It also emphasizes the need for data protection measures to be put in place to safeguard individuals' personal data. In wake of disturbing rise in violence against advocates within court premises, a group of concerned advocates have approached the Delhi High Court with a plea to ensure the implementation of the Advocates Protection Act in the national capital. This move comes in response of the tragic killing of the advocate Virendra Kumar, which has further underscored the pressing need for measures to safeguard the lives and well-being of lawyers. The petitioners have stressed that such incidents of violence not only pose a direct threat to the advocates but also impede the administration of justice and undermine the rule of law. In the end, we have international news. In major relief for thousands of Indian techies, a US court has dismissed a lawsuit that sought to deny work authorization to spouses of H-1B visa holders in queue for green card, ending the uncertainty that has dogged them for years. A district court of Washington ruled that the work authorization is in compliance with the Immigration and Naturalization Act and supported by decades of executive branch practice and both explicit and implicit congressional ratification of that practice. Italian Prime Minister Giorgia Meloni's party have proposed a draft bill in the parliament that would impose fine of up to £1 million on public and private entities that use foreign terms, particularly English, instead of Italian in official communications. This comes a day after Italy said it was temporarily blocking ChatGPT over data privacy concerns, the first Western country to take such action against the popular artificial intelligence chat box. Donald Trump has become the first US president ever to be charged with a crime as he surrendered in Manhattan court. He has pleaded not guilty to the 34-count felony indictment in which the prosecutors has claimed that he conspired to illegally influence the 2016 presidential elections through hush money payments to two women. Thank you for watching and have a nice day. This is a weekly program, and to get more information, please check the description box, and for weekly updates, like and subscribe to our channel.